38 years in the oil patch teaches you to read a situation before it turns dangerous. You learn to smell a problem the way you smell sour gas on a winter morning, before it's visible, before anyone else has noticed, while there's still time to act. I thought that instinct would retire along with me. I was wrong. I was standing on the landing of the staircase in our home when I saw my son-in-law do it. Below me, nearly 100 guests filled the main floor. Colleagues from my old company, neighbors from the Crescent, my wife's book club, friends our daughter had collected over the years. The wine was flowing, the caterers were moving through the crowd with trays, and the jazz quartet my wife had hired was playing something warm and familiar near the fireplace. It was supposed to be a celebration, our 35th wedding anniversary, the party my wife had been planning since February. My son-in-law was standing near the drinks table with his back half turned to the room. I watched him check his phone, check over his shoulder, and then, with a speed I wouldn't have believed if I hadn't seen it myself, pull something from the inside pocket of his blazer and tip it into the glass sitting alone on the corner of the table. The glass with my initials etched into the base, the one my wife had commissioned from an artisan in Canmore last summer, just for this night. He stirred it twice with his finger. Then he picked up the tray and turned toward the staircase with a smile already forming on his face. I had perhaps 4 seconds. I used them. 38 years of pipeline engineering means your hands know what to do before your brain finishes catching up. You learn to work precisely, under pressure, without hesitation. As I came down the last few steps and reached for my glass, someone across the room called my son-in-law's name. He turned his head. That was enough. My hand moved once. When he turned back, I was holding the glass that had been sitting to the left of the tray. He was holding the one on the right, the one with my initials, the one with whatever he dropped into it. "There you are," he said, and his smile didn't waver. "We were all waiting on you." "To 35 years," he said, raising the glass. "To the next 35, I replied. He drained it in 2 long swallows. I took a careful sip of mine and watched his eyes. I counted 11 minutes before he started to show symptoms. He made it through the first 2 minutes of his toast without trouble, polished, warm, the kind of son-in-law performance that had charmed every person in that room for the last 4 years. Then, near the end, his voice began to slip. He repeated himself. He reached out and grabbed the edge of the podium. His pupils had constricted to near pinpoints under the chandelier light, and when he looked at me across the room, there was a moment, just one, where the performance fell away completely. He understood what had happened, and then he fell forward and took the table with him. The next hour was chaos. I moved through like a man working a blowout, controlled, eyes forward, everything unnecessary filtered out. I rode in the ambulance. I spoke quietly to the paramedic, a young woman who had attended a safety fundraiser I'd chaired 2 years ago, and I told her the symptoms were consistent with a fentanyl exposure, not cardiac arrest, and that we needed blood and urine drawn before any IV fluids went in. She hesitated, then nodded. I palmed the vials when she had finished. I was not going to let that evidence disappear into a standard intake procedure. At the hospital, my wife arrived with my daughter. My wife looked at me the way you look at a stranger who has done something incomprehensible. She didn't ask if I was all right. She went straight to his bedside and held his hand, and when he regained consciousness and pointed across the room and said I had switched the glasses, that I had tried to poison him, I watched my wife's face move through something I had not seen in 35 years of marriage. She believed him, not reluctantly, not after any hesitation worth measuring. She believed him the way you believe someone you have already decided to trust. I drove home alone. He had been using the study I'd let him work from when he and my daughter moved to a house nearby 2 years ago. I had given him a key and never thought twice about it. That room was where I found the safe behind the landscape painting on the west wall. A digital model, the kind that looks secure until someone who spent too many Sundays on a drill camp with a locksmith takes a proper look at it. 6 minutes, give or take. What was inside was not what I expected. There were bank statements, not his personal accounts. Credit lines drawn against investment properties he had convinced my daughter to co-sign. Gambling debts logged in what appeared to be correspondence from a private offshore betting operation. a stack of demand letters from a collections firm in Vancouver. The numbers were significant enough to make my hands go still, and beneath all of it, two documents that changed the air in the room entirely. The first was a power of attorney, an enduring power of attorney drawn up under Alberta legislation, with my signature on it. I had not signed that document. The language granted my son-in-law full authority over my financial affairs in the event of my incapacity, which the attached medical letter, signed by a physician whose name I did not recognize, described as increasingly likely given my documented cognitive deterioration. Incidents were listed, arguments I hadn't had, lapses I hadn't experienced, a diagnosis I had never received. The second document was a life insurance policy through Manulife. The insured was me. The coverage was $2 million. The beneficiary was my son-in-law. The policy had been in force for 4 days. Plan A: if the drug left me alive but brain damaged, the power of attorney took effect, and he controlled everything: the Calgary house, the Canmore cabin, the RRSPs, the investment portfolio, all of it. Plan B: if my 64-year-old body gave out on the living room floor in front of 100 witnesses, he collected $2 million and stepped back into the shadows of grief. He had covered both sides of the coin. He had done it while sitting at my dining room table eating the food my wife cooked and calling her by a name that made her smile. I photographed every page. I put everything back exactly as I had found it. I reset the painting, wiped down what I'd touched, and sat in my car in the driveway for a long time before I drove back to the hospital to collect my jacket. My wife came home at 4 in the morning. I heard her stop when she saw me in the dark of the living room. She turned on the lamp. What followed, I won't recount in full. The short version is that she had made her decision, and the decision was not me. She said I had always resented him. She said the doctors at the hospital that night had agreed my behavior was troubling, and that perhaps it was time I spoke to someone. She said she didn't recognize me anymore. She went upstairs, and I heard the lock on the guest room door. I waited until the water came on in the ensuite. Then I unlocked her phone. She had used our anniversary date as the passcode, which felt, in that moment, like a small, dark joke, and I installed the monitoring software I had purchased 3 months earlier, when I first noticed money leaving our joint account in amounts just small enough not to trigger a bank alert. I had bought the software and then sat on it, because using it felt like something a paranoid man did. I understood now that I had not been paranoid. I had only been slow. I placed the phone back where she had left it and went to my study to wait. 20 minutes later, the audio feed spiked. She had called him. I put in my earbuds and sat very still. He answered on the second ring, and even through the phone, even weakened by what the fentanyl had done to his system, the person I heard was not the man my daughter had married. He was efficient, focused. He told my wife that the frozen accounts, which he had discovered within hours of my signing the emergency paperwork with my lawyer that afternoon, had changed the timeline. He needed money she could access through her spousal RRSP. He had a lawyer who could file an incapacity application under the Adult Guardianship and Trusteeship Act as early as Monday morning. All he needed was her signed statement regarding the events at the party, and $80,000 to retain the legal team. My wife said she would take care of it. She would transfer the funds in the morning, before the branch opened for general business. She called him sweetheart. I sat in the dark and listened to the sound of 35 years ending in a 2-minute phone call. By 7 the next morning, I was sitting across from my lawyer, an old friend who had handled every significant document in my adult life and who arrived at his office with 2 coffees, and the expression of a man who understood that what I was about to tell him was the worst conversation we had ever had. I laid the photographs from the safe on the desk. I put the printed call transcript beside them. I set the toxicology vials from the ambulance on top of those. He was quiet for a long moment. Then he started typing. By 9 that morning, every joint account was frozen. Both credit cards tied to my SIN number were canceled. The Canmore property was registered under a legal notice preventing any transfer or financing without my explicit written consent before a notary. The investment portfolio was moved into a sole access account. I called the 3 banks involved personally, and each time the hold music played, I stared at the framed photograph of my daughter at her convocation and kept my breathing even. My son-in-law called 11 minutes after the last account locked. He was not polite. I let it go to voicemail, then called him back. He told me I had made a mistake I didn't understand yet. He said there were things about my years as vice president of Operations that certain people, the Alberta Energy Regulator, a few journalists he claimed to know, might find interesting. He had apparently gone through my old filing boxes in the storage room while I was at the hospital one afternoon. He had found records from 2007, when I had approved a contractor's safety documentation, knowing the site inspection had been incomplete. We were 12 days from a layoff that would have put 63 men out of work before Christmas, and the inspection failure was a paperwork gap, not a structural one. But I had signed off anyway, and the records showed it clearly. He gave me until noon to wire $100,000 to an account number he texted. Otherwise, he would make 2 phone calls before lunch. He was right that the story would be embarrassing. He was wrong that it would break me. Within 2 hours, I had signed statements from 4 men who had been on that site in 2007 and were willing to say exactly what had happened and why, and that not one worker had ever faced actual physical risk. The paperwork violation was real. The danger had not been. It was not the weapon he believed it was, and I sent his blackmail texts to my lawyer with a note to add them to the file. The court application came the following Monday, an emergency declaration of incapacity filed jointly by my wife and my son-in-law. I appeared without counsel. The judge looked at me with the specific patience reserved for people she had already decided didn't fully understand their own situation. My son-in-law sat in the gallery in a neck brace. My daughter sat beside him. My wife sat behind them both and did not look at me once. Their expert, a psychiatrist whose clinic I had found, in 15 minutes of searching the night before, had accumulated 2 formal complaints before the Alberta College of Physicians in 4 years, spoke for 20 minutes about paranoia, cognitive decline, and erratic financial behavior. He cited my account freezes as evidence of a manic episode. He cited my presence in the ambulance as aggression. When it was my turn, I walked to the front of the room and stood in front of him. I asked what the standard imaging protocol was for diagnosing the frontal lobe deterioration he had described. He said behavioral observation was clinically valid. I asked which of my behaviors he had personally observed, given that he had never spoken to me before this morning. He began to describe documentation provided by the petitioners. I asked whether he understood that a diagnosis issued solely on information provided by parties with a documented financial interest in the outcome was not a diagnosis. It was a service. He did not answer that one. I submitted the security camera footage from the drinks table. I had installed cameras 3 months ago after finding items moved in my study. His lawyer told the judge my son-in-law was simply adding sweetener to the champagne, that he had a sensitivity to dry vintages. I submitted the toxicology report. The lawyer said the chain of custody was irregular given my involvement. I submitted the life insurance policy activated 4 days before the party. The lawyer called it prudent financial planning. He was skilled, I will give him that, and I could feel the room tilting against me. The judge picked up her pen. She said that given the conflicting evidence, she was inclined to grant a temporary order, pending an independent assessment. She said it was in my best interest. The pen moved toward the paper. The doors at the back of the courtroom came open, the way doors only open when someone has held themselves together until the very last moment and has nothing left to hold with. She came down the center aisle with her right eye swollen shut and dried blood along her lower jaw. One hand pressed against her ribs, the other holding a phone out in front of her like it was the only thing keeping her upright. She was my son-in-law's former assistant. She had worked with him for 2.5 years. She told the court in a voice that only broke once that he had told her my daughter was temporary. He had told her the old man's money would resolve everything they needed to start over. She said he had come to her apartment the previous night in a rage about the frozen accounts, and what had happened there was why she looked the way she looked. My son-in-law stood up. The neck brace came off in the motion. Though I don't think he noticed, the bailiff moved. She pressed play on the phone. It connected to the courtroom's display system. His voice filled the room, recorded and sent to her as a voice note on the evening of the party an hour before the toast. The plan, the timeline, the drug, the expected result. All of it in his own words, because he had been so certain of the outcome that he hadn't once considered what certainty costs when you're wrong. My daughter did not make a sound. She stood up very slowly from her seat, looked at the man beside her, and then simply left the room in every way that mattered before her body caught up. She went straight down, not the dramatic faint of films, but the complete shutdown of a person whose entire understanding of the last 4 years has just been unmade. I was across the courtroom before the bailiff reached her. I knew from the way she fell that it was shock, not her heart. I loosened her collar, turned her on her side, checked her airway, and told the court clerk to call for an ambulance. My voice stayed level. You learn that on remote work sites, you learn that panic is a luxury no one around you can afford. She was conscious by the time the paramedics arrived. She looked up at me from the floor, and her face did something I hadn't seen since she was 9 years old and had come off her bike in the back lane behind our old house. She looked at me like I was the safest thing in the room. He was taken out in handcuffs. The charges took several days to fully consolidate: fraud, uttering threats, administering a noxious substance with intent to harm, blackmail, assault causing bodily harm. He eventually pled to 4 of 8 counts. He will be away for some time. The financial untangling took months. The condo development scheme he had used as a vehicle to drain my daughter's savings was a total loss. I covered what I could, quietly, without framing it as a rescue. The Canmore cabin sold in 5 weeks. I kept the Calgary house. My wife moved out in November. The separation proceeded quietly, and with a sadness I had not adequately prepared for. She had not been fully complicit in what he had done, but she had stood on the wrong side of the room when the moment came, and that is not something that dissolves with an explanation. What I had not known, not until my lawyer requested an independent medical assessment at my insistence, was that my wife had been consuming something she hadn't been aware of. The herbal tea blend my son-in-law had gifted her early in the marriage, replenished by him every 2 months without exception, had been laced with low doses of a benzodiazepine. Nothing dramatic. Enough, accumulated over months, to soften a person's judgment, to make them more deferential, more willing to accept the version of events they were given. She had not been conspiring against me with full clarity of mind. She had been slowly adjusted, like a dial turned so gradually you never feel the room getting colder. When I brought her the report, she was sitting in the small apartment she had rented in the southwest end of the city. She read it without speaking. Then she looked at me with the expression of someone who has wronged another person in a way that can't be entirely repaired, even with a full account of the reasons. I told her I would ensure she had enough. I told her I forgave her, and I meant it in the way that forgiveness is sometimes genuine, without requiring a return to what was before. I told her to change her tea. She nodded and didn't say anything else, and I walked back to my car through a light October rain. My daughter passed her recertification exam in the spring and went back to work. She took a position at a hospital about 40 minutes outside the city. Day shifts 3 days a week to start. She has a small rented house, a sensible car, and a schedule full enough that she doesn't have time to sit still with everything that happened, which I believe is deliberate and which I respect. She came for dinner 2 Sundays ago and brought a bottle of Okanagan Red and a small potted plant she said was impossible to kill. She left it on my kitchen windowsill. I watered it this morning. It is doing well. The trust documents I restructured last fall. The terms are straightforward. The principal is untouchable, designated on my death to an engineering scholarship fund at the University of Calgary for students from northern Alberta communities. The returns are available to my family, my daughter, eventual grandchildren, my wife's monthly support, but tied to demonstrable self-sufficiency. You work, you study, you live within your means. The trust matches your effort, dollar for dollar. You wait for something to arrive on its own, you receive nothing. It is not generous in the easy sense. I believe it is honest in the only sense that lasts. I still take my coffee on the back deck in the mornings when the weather allows. On clear days you can see the front range of the Rockies from the far end of the yard, the way you could from my very first apartment in this city 40 years ago. I used to look past it without seeing it. I don't anymore. There is a certain kind of man who mistakes age for the end of vigilance. He sees gray hair and a quieter life, and reads it as a signal that the defenses have come down. He sees a balance sheet rather than a person. He sees a payout rather than a history. He forgets that the people who built something from nothing spent 4 decades learning precisely how the world tries to take it from them. I stood on the back deck last Saturday evening with a glass of that Okanagan red my daughter had brought. The mountains were visible just above the tree line, catching the last of the light. I didn't make a speech. There was no one to hear one, but I thought about that staircase landing, and the 4 seconds, and the glass with my initials on it sitting on the table below, and the fact that the man who had filled it believed the old engineer was already finished. He miscalculated. They usually do.